Excuse me, it's 1:30 on November 10, and I'll call this meeting to order.
Oh, we're here for a minute. Okay.
Absolutely.
Deborah, could we have a roll call?
Yes, Hurt,
Here.
Hildreth,
Here.
Bentley,
Here.
and Hamachi.
Here.
Are there any suggested changes or additions to the report of the meeting on October 13?
No.
They stand approved as submitted. Do we have a member forum?
So we don't have any in-person speakers and there are no Zoom speakers, so that concludes the member forum.
Thank you. And the chair does not have a report. There is no unfinished business. Let's move on to new business. Jeff, would you like to tell us about the review of the policies?
Okay, so we had the three policies go to the board after review at this committee level. And they had a few questions and suggested edits that they wanted the committee to review and keep them kind of all together. So although there's not a lot of substance to policy 100 in terms of revisions, we'll keep them all kind of moving at the same time because they're intertwined. So policy 100, the main change is we updated the draft and it says, I think we added the phrase consistent with policy 101.1.
That was good.
And then policy 101.1, the hearing procedures, consistency review. So while no substantive content edits were required, formatting and references were reviewed to align with policy 100. Coordination, policy 101 will move forward in tandem with policy 100 to ensure uniform language. And then policy 104.5, the harassment policy, is where there was a few additional changes made in relation to the language. We added in the policy that went to the board was lacking the actual discussion on and the addition of the online portion. So that is definitely in there. And then we added emails and text messages in addition to phone calls. There was clarification, update, introductory, and behavioral sections to confirm that the policy applies to residents, guests, staff, and vendors, not just members. And then the law enforcement language was updated to clarify that the member needs to report, although we will assist. And then the reference to members in the disciplinary section was not modified as it pertains to member hearings, although there may be some discussion on whether or not you want to list that as members or residents. As if you look at policy 101, I believe it was, refers to in several places the member or resident. So for consistency throughout these, we may want to consider putting member or resident.
Okay.
So that's the three of them.
Okay. Now, as far as, do we need to request that be amended to include member or resident?
If you want to make that change, you can direct us to make that change. I do have a question into Jeff Beaumont just to clarify, because a member is a resident.
Right.
That's right.
A resident has other classifications, so should we just list it as resident instead of member or resident? But I want to make sure I'm not missing something within that designation, because a member is definitely a defined.
As a resident.
But I mean, it is a defined term. You have benefits as a member that you don't as a resident.
Could we possibly have a member with 2 units? And there is a problem with the second unit, not the one they live in, but the other unit that a resident lives in. And the disciplinary has to come back to that, and they're not residing in there because they own this one and this is where they live. And how do we tie those two together?
So I don't know that you would ever tie the two. Your disciplinary action is specific to either the member or the resident. If if they're residing in the other unit. So you can, if you have a resident who's not a member, so like a co-occupant or so forth, they still have privileges to use amenities and they could still be subject to disciplinary procedures.
But the member is not responsible for the resident.
No.
Well, what if I'm the member and I have no more storage in my place and I decide that's the spot I'm gonna store my flammable material, which we probably don't wanna have done in a garage. And so that's being done by the member, but not necessarily by the resident who lives there. I'm just saying, sometimes a member having two units utilizes both units to do different things in. So I don't want to, as long as it's gonna tie back to if the problem belongs to, it's happening here with this resident, but this is the member who's also causing that problem to happen, that we can tie into both.
I think you would tie any disciplinary hearing or action to the cause of that, whether it is the member or the resident or a lessee or whomever.
I have a question about 100, policy 100. And I apologize that I wasn't here that first time you guys went over it, but that fine of $100, like how is that determined and in what situation would you do that?
So the board can determine that a fine should be imposed for any type of violation that it deems worthy of a fine. The maximum fine, I believe per statute, is $100 that can be levied.
Isn't that from the state?
Isn't that from the, yeah.
Yeah.
Dave Sterling. It doesn't have to be imposed, though. It can be imposed.
You can impose a restriction on use of amenities, you can do other things, but you can also impose a fine up to $100.
So all kinds of options, yeah.
Yes.
Of which you'll never collect.
Well, if they sell their unit, you would collect it at that point.
So just on, I understand, because I think that the mutuals go on the same line of if there is an infraction, let's say a contractor was doing something wrong, they only charge them $100, which seems like more of just a slap, honestly. But if it says more than one infraction, and that number can go up, can it? It's not $100 per, or if they, I mean, can you, that's the starting point, and then they can go up from there, or can they? I don't know if they can or
I
not.
believe it's $100 per infraction. But like a contractor doing something illegal, that would be a different scenario. This is talking about a member or resident violating a specific policy, procedure, or rule, not necessarily associated with a mutual. This is on RWC property.
We just had a review of the policy and the fines and things, and they, according to Dave Sterling, and we had a real long look at this, they can go up quite high, like $10,000 in the long run.
After the first?
Particularly if there is any substantial damage to anything. And so if it is not corrected and things continue, it can go up very high. And this, we just had our Dave Sterling.
But keep in mind that we're only talking about RWC and violations to our policies.
Okay, so let's apply that to our policy then. If somebody did something that they weren't supposed to do, and then they did it again and again, and it's the same person or group of people, if somebody's using one of our amenities, can it increase like Mary was talking, or is it just $100?
I believe it's $100 per infraction, but you have other remedies. You could suspend them from use of those amenities if they're continuing not to use them properly.
Jeff, could you clarify when you were talking about whether you wanted to add member or resident, or you were checking with the attorney on that? Was that 101, which policy was that?
So if you look in 100, we have a few places where it says member or resident.
Right. Yeah.
And then if you look at, say, policy 104.5, you go towards the end, it says, for example, members found to have willfully and or habitually violated this policy may be subject to discipline pursuant to Rossmore Walnut Creek policy. So like there, should it say members or residents found? So it's consistent with the other policy.
Well, I think since we're moving toward consistency, we should use the same language.
Right, because it could be a hearing subject to a resident who is not necessarily a member.
Are there any other questions on 100?
Well, I wanted to clarify, do you need us to do some kind of a motion or authorization if you get information from the attorney? We want to be able to reflect that and not hold this up for another meeting, so.
Right, so you can give, say, either have it resident or member or resident consistent with the recommendation from our legal counsel.
Do we need to make a motion to that effect?
And is this this is a motion for all of these to be moved forward again?
But I think you have other questions before you're ready for that.
Okay, on 101.1, does that policy apply to all hearings? We have hearings about club complaints about clubs, policy disputes. Does that apply to everything?
This is a process for a hearing to do with disciplinary violations of a policy, procedure, or rule. So if somebody wanted to appeal the membership transfer fee, or you had a dispute between club members, this wouldn't necessarily apply. This is strictly if a member or resident has a violation of a procedure, policy, or rule.
Maybe we should clarify that, maybe in that first paragraph, because we have hearings about other things. And if someone was going down the list of policies and just saw hearing, and they had been called in for a more generic hearing, this would not apply to them.
So define the subject matter,
Uh,
like it's defined for our executive sessions. So
Well, in
as it
regards to
pertains
disciplinary-
policies,
Disciplinary
procedures, and rules from
hearings?
RWC.
yeah, I hadn't thought that.
Yeah, disciplinary hearings are actions related to violations of,
There you go.
Where would you insert that?
so
language?
kind of be in your title.
Instead of,
Subject would be,
Subject?
Yeah.
subject would be hearings for disciplinary hearings for violations of procedures, policies, or rules.
procedures.
So by changing the subject,
Yeah, I think you capture it.
Can I continue? The first bullet, we referenced 101.1 in policy 100. Should we add to that, at the end of that first bullet, should we add as indicated in policy 100? Because you're talking about the actual, well, never mind, I don't think you need that.
Okay.
And then in the second bullet, they use the word violation. Is it always a violation? You're there for disciplinary, I guess it is.
an alleged violation.
No. And then under the topic of the hearing, a hearing by the board will be informal. That word kind of stuck out because the hearings are actually pretty structured. So I don't know if we need that word informal. What was the originator implying by informal? We don't all talk at once, you know, we have this set procedure. So we just
I
take
think
that.
the terminology is related to, it's not a court proceeding. It's more of a discussion at the leisure or direction of the board.
Okay,
That it's not who speaks when you speak.
okay.
It's-
Okay, let's see.
Are there other questions?
That's it.
I have a question. I'm trying not to use a real example, but if a staff member accuses a resident of a violation, are they supposed to run that through you before they send them a letter? That's my clarifying question.
So with this, it is the general manager or their designee. So typically a department head would have discretion. Although say a manager would not. But if a department head was to restrict or take away a privilege, it would be subject to this actual process. So it would come to a hearing before any restrictions of privilege were taken away under this process.
Thank you.
I thought the changes were good.
Are there any other questions or considerations? Do we need to make motions at this point?
We do,
Well, I have more questions
Oh, I'm sorry.
about 104.5. Okay, I'm a little confused. So we added something about referring to HR. So in the various situations that could occur about harassment, you have vendor to resident harassment. That would go to HR or the departments somehow, you?
yeah, it would go to,
And then if it's staff to resident, that would go to HR.
mhm,
Resident to resident would come to this policy. Then we talked about guests. So would a guest ever come forward and say a resident harassed them?
they
And would
could.
that-
They could.
Okay. And then guest to resident, would we just get rid of the guest or, I mean, we talk about member again.
So we would still have a process because let's say the guest is a resident's son or daughter and they are accused of doing something. You would still want to have a process because the,
Okay, so. So I'm thinking about that term, member. So any correspondence, say it was the member's guest that created the harassment. The letter would still go to the member because they're responsible for the guest.
right, so we would, you could ultimately say that this guest of yours is no longer welcome. Or we say in all of the guest use policy that a member is responsible for the actions of their guest and they have to be with them at all times. So if your guest is doing something and you permit it, You're ultimately.
That works. And then we added, okay, we added that paragraph on the second page. This policy applies to harassment, bullying,
And the social media.
abusive conduct on social media. Shouldn't that be added as another bullet point because it's another behavior? Like we list all those bullet points above that. Behaviors directed toward residents, guest staff. We'll like move this here.
So instead of, so after the last bullet, instead of this initial sentence, say bullying or abusive conduct on social media platforms, which are strictly prohibited. And then another bullet point, this includes but is not limited to posting, sharing, or threatening.
So you would just move it up and make it another bullet, that long, longer list of bullets.
So not two separate items?
Two separate items.
Because it's saying this includes but is not limited to posting or sharing threatening, defamatory or derogatory content. Is that tied to the social media? Okay.
Well, I don't know, I think because that came
Or
in
does
as
it tie
one
to
kind of
email,
paragraph.
text messages? So is this a sentence? So what I'm getting at is this structure, this includes but is not limited to posting or sharing threatening, derogatory content. Is that a sentence all by itself at the end of this, summarizing all of this? Or is it another bullet point, or is it tied to just the social media? That's my question.
What if you take this policy applies to harassment, bullying, and abusive conduct on social media, and you move that up to the list of bullets up above, and it just says, start with harassment, bullying, or abusive conduct on social media platforms.
Yeah, I like that.
So get rid of this policy applies to, and you just start with harassment, bullying, and it's just a bullet with the list of other bullets.
At the end, if I'm understanding correctly, just at the end there, right?
I don't mean to be so picky about this, but the next paragraph starts, members have found to have willfully and or habitually violated the policy. Subject to discipline pursuant to Ross Malona Creek policy. Can we put in the policy that's referenced there?
So this would be the 100?
Mm-hmm. That's the policy for enforcement.
Okay.
So it's as indicated in policy 100.
So has Jeff looked at all of this?
Yeah. He drafted all of the
Another
red line.
Another reference to policy 100 and 101. And down here, alleged to be in violation will be sent from Ross Malona Creek Board President, and a hearing will be scheduled as indicated in policies 100 and 101. I tried to read this as a resident who knew nothing. And
That's pretty
that's
good.
why I'm suggesting all these references. And since it's already stated elsewhere that members are responsible for their guests, we don't have to reference that in here because ultimately it would be.
Yeah, I think that just strictly falls under the guest use policy.
And then would we need to stipulate somewhere that vendor to resident or staff to resident would be, that harassment would be handled elsewhere, so that when people see harassment policy, they realize it's just resident to resident, residents to staff.
I think that's what was, sorry,
Go ahead.
no,
Yeah, I think that's pretty clearly picked up with other policies, that this is only pertaining to disciplinary hearing or actions related to member interaction or resident interaction. I don't think you need to state that harassment by employees would be dealt with separately.
Yeah.
Because this governs the member or resident interactions.
I had a question for the title where it says to preclude harassment among residents, guests, staff and vendors. Are you wanting to, if legal counsel wants to change that, am I changing that to member or resident as well? In the purpose of the harassment policy 104.5 at the very top. So it's calling out to preclude harassment among these groups of people. Are we also mentioning among members or residents, guests, staff and vendors, or?
Yeah, I think throughout, or I would suggest throughout all of these documents, we kind of refer to or get direction from Jeff if there needs to be a delineation between resident and member. If you could just say resident,
Yeah.
because a member is a resident.
So it's consistent across.
Yeah.
Any other questions? Any other concerns? Now, how are we gonna make the motion? Can we, do you have, if somebody were to make a motion at this point, is there a way that it can be stated so that we don't have to repeat all this?
Just list the.
Absolutely.
You could just
Is there a motion?
say the policy committee recommends to the
Revised
board
policies.
adoption of the revised
Yeah.
Okay,
policy, or the policies as revised.
With further clarification for member or resident consistency from legal counsel.
is there a motion?
I'll move it if I don't have to say it all again. You have it there, I think, Deborah.
I look at the intent.
Okay, thanks.
Is there a second?
I'll second.
Any further discussion?
I have one question about members being responsible for guests, like, I mean, if somebody actually hauled off and injured someone, like, smacked them, broke their arm, I mean, under criminal law, the member's not gonna be responsible for that, right? That was an intentional act by this person. So I don't know if, Jeff, you talked to your lawyer about like using that term. I mean, yeah, we have a guest policy about being responsible for your guests, but when it comes to an actual like physical attack or something.
That would definitely fall under assault that would be reported against that individual.
Exactly.
If we have a guest commit theft or, burglary, that would fall under the individual that's conducting the criminal activity. This is more if you bring your guest to the pool and they're violating the rules and you're not paying
They
attention to
bring
them.
kids to Dollar.
You would then be, subject to the policy. But actual violations of the law or something would be, obviously those. Now, if you are part of that, or you're by bringing it in and knowing that there's a lot of different elements to it, I guess you could probably argue,
Case
but
by case.
Yeah.
really it's intended for violations of any of the rules that we have in place.
Or like bringing your dog in or.
Most of our policies don't deal with physical activities. They deal more with the breaking the rules or harassment or something like that.
Yeah, kind of like you were saying, if you brought your guest brought their dog in and they
Right.
went swimming in the pool. we
You're
could,
not gonna
Right.
relax.
Okay.
Right, you gotta vote here.
Any further discussion? Can we have a,
Certainly. Roll call vote it is. Hurt,
yes?
Hildreth,
Yes.
Bentley,
Yes.
and Hamachi.
Yes.
It's unanimous.
All right, can we move on to the next one? Again, you want to speak to this issue?
yeah, so there's actually no changes, I believe, to this one. And we just wanted to keep them running consistent. And what this one does is just adds that language to the policy for every one of our policies, procedures, or rules where there is potential action for violation of those. It would say, violation of policies, procedures, or rules will be reviewed and acted upon consistent with policy 100, which may be found on the myrossmore.com website or upon request at the administrative offices at Gateway Clubhouse. And so that consistent tagline would be on all of our, say, golf course rules, fitness center rules, etc.
Do we need to have a motion to add that and then go back for a first reading or?
Yes.
Okay. Any questions?
Is this, because we do call out some specific areas, is this also for one of the other, like lawn bowling or bocce or pickleball or tennis? Would this be something that'd be posted there too, or?
Yep. Because we have rules for use of those amenities, even though it's not a staffed area.
Yeah.
There's still rules for use of the tennis courts and so forth.
Who does that? Do you go in and just add it to all the?
Yes, I actually have a meeting scheduled after this December 4th meeting, depending on how the board wants to move forward. If it's a pretty clear picture, you guys want to move forward with that 100 violation statement. I already have those rules vetted out and ready to go.
Oh,
Jeff's a review and approval on that Friday. I know it's a first reading, but we have to start the ball rolling.
Wow, very good. Are there any questions or discussion? Do we need a motion then to adopt that?
Mhm. So you get motion to recommend that the board approve.
Approve. Okay. Is there such a motion?
I move that the board amend all facility use rules to include the statement mentioned in 7B.
Is there a second? Additional discussion or questions? If not, can we have a roll call vote?
Certainly, Hurt,
Yes,
Hildreth,
yes.
Bentley,
Yes.
and Hamachi.
Yes.
It's unanimous.
thank you. It's very unlikely that we'll need to have a policy meeting in December, so most likely the next meeting will be January 12th.
Okay, so if no business, it'll be canceled?
Unless something comes up, but right now it looks like we'll be waiting till January 12th.
So the items to do with Rotary's request for the request for the fee waiver and reservation and guest use, all of those policies will start to bring in early January.
Okay.
If there's no further business, this meeting is adjourned.